We all know if it isn't in writing, it didn't happen. And contracts are no different. They're the foundation of any successful business deal. They prevent misunderstandings, they protect your interest, and they minimize risk. So in today's episode, we're going to discuss the importance of contracts, what a breach of contract is, and we're also going to share real-world examples, including legal battles between big names like Rida, NSYNC, and Disney. Tune in and let us know what you think. Hey, lady bosses, are you working even after putting the kids to bed but still not getting results?
Are you tired of spending money on ads that aren't getting engagement?
Do you feel burdened that you aren't fulfilling your purpose in life because you are so consumed with work?
I'm your host, Brooke Bolts. I'm an attorney and founder of Bolts Legal. I started my business and in 1 year was bringing in 7 figures and am now bringing in multi-7 figures.
And I'm your co-host, Rachel Bolts, owner of Bolts Media. I've helped many businesses build their online presence and increase their revenue through digital marketing.
Want to hear how we did it?
We are here to help you achieve your goals personally, professionally, and spiritually.
So kick off your high heels, sit back, and let's ignite that passion.
We're Miss Biz, where we're putting the miss in biz.
Let's get biz done. I have been avoiding today's topic. I don't know why. It's breach of contract and contract law. And this is what I do every day. I handle breach of contract cases. I read contracts every day. But in my mind, it's like taking me back to law school, and also just seems dry and boring to me. And we try so hard to keep our podcast engaging that, to me, talking about contracts is boring. But as Rachel keeps reminding me every week, she's like, we got to do that contract episode. And it is important. So stick with us. We've done our best to try to make it engaging, but these are important principles that you need to know as a business owner.
Yeah, so we're going to break down the basics. So basically, a contract is a legally enforceable agreement. It can be written, oral, or implied, and it's between 2 or more parties. And there are a few key elements that make a contract binding. So the first is the offer. This is the clear proposal outlining what one party is willing to do. Next is the acceptance. So that is the other party's agreement to the offer's terms. And then third is consideration. That's the value exchange where each party gives up or gains in the agreement.
Right. So an example of a contract is an example that I do every day. We are trying to settle a lawsuit. We make a settlement offer of X dollars to resolve the lawsuit for someone's injury claim. And if it's accepted, then case is over. We've reached an agreement. Contract is entered into. And the consideration is that each party has to be benefiting in some way from that agreement. If it's only one side who's benefiting, there's no value exchange.
Right.
Then it's oftentimes not an enforceable contract.
And here's the thing, if you're a new business owner, you never know when you need a contract until you do, buddy. You will find out the hard way, especially if you're not getting paid. So it's definitely worth the investment in looking into how to get a contract made just to protect yourself and your business.
A few red flag things to look for when you're signing contracts that have an impact are, 1, attorney's fees. The law, at least in Florida, is that if there's not a statute or contract that gives you a right to attorney's fees, then you're not entitled to them. So what prevents people a lot of times from being able to try to enforce their contract legally is if the contract doesn't say that you get your attorney's fees paid back for filing this legal action, then you're out of pocket. So if someone did you wrong to the tune of $10,000, but your legal fees are going to cost $20,000, then it doesn't make sense to go filing a breach of contract action. But if your contract gives the right to attorney's fees to the prevailing party, then now it makes it make more sense because you have the potential to recoup your $10,000 plus your $20,000 in attorney's fees. So that's a really important provision to look for. But it works both ways. If you lose that breach of contract, then guess what? You have to pay the other side's attorney's fees. So whoever is the prevailing party is who gets their attorney's fees paid. So it goes both ways.
I think I have some referrals for you. We'll find out. So there are a few different types of contracts. There's a bilateral contract, and that's where both sides make promises. So an example of this would be, I'll design your website and you pay me X amount of dollars. The second example of a contract type is called a unilateral contract. That's where one party promises something in exchange for an action. So I'll offer a reward for anyone who finds my lost dog. The next example is called an expressed contract. That's where the terms are written down in detail. And then there's implied. That is where the agreement is inferred of the party's conduct. So you pay a restaurant's bill, they provide food.
When it comes to the written contract, it's important to look up in your state what contracts are required to be in writing. For example, a real estate contract. In Florida, it must be in writing. You cannot sell a property orally. So certain things you can do orally, some things you cannot, but you can look it up easily enough with a Google search. And when it comes to writing, I remember this from law school, that even writing on the back of a napkin can be enough to be considered an express contract. So it doesn't have to be a formal typed up signed, notarized document. If you write it on the back of a napkin and both sides sign it, that can be enough to create an express contract. Implied contract is based on the conduct. So I had a lawsuit one time I defended, went all the way to trial, where my client was an employer and one of her former employees alleged that she'd not been paid commissions that she'd earned while working. But when we pulled out the employment agreements, when we pulled out the wage agreements and just all the evidence, the only evidence that she was supposed to be paid some commissions was her own statement. There was nothing in writing, and there were no actions that supported that. She'd never been paid commissions during the time she was working there, and just the evidence didn't support her verbal claim. And so we won that trial, and my client was vindicated against the allegation of not paying someone's wages. But it's also a lesson that while you can create an oral contract, it's sometimes hard to enforce those because it's kind of a he said, she said situation many times.
So when in doubt, write it on a napkin or send an email or something to back up your written agreement. It's better than nothing. So contracts, they're super important for your business. Obviously, it's going to provide a lot of clarity and certainty. It's also going to reduce any sort of risk that you might have, maybe not all risk, but a majority of it, to help protect you from financial loss. And it also just looks professional too if you have a contract, especially if that's something that your competitors have or it's a common field for you to have a contract. You're going to want to make sure that you are providing your clients with that. It's really going to save you.
Another red flag thing to look for when you're reviewing contracts is the word arbitration. A lot of people may not know what that means or not understand the significance of it. Where I've seen this recently was signing an agreement at a doctor's office that it said mandatory arbitration. So what that means is if you have a dispute with whoever the other party is, in this case it would be a doctor, let's say that they did some medical malpractice to you in the treatment that they provided, you would not have the right to file a lawsuit against them. Instead, you'd have to go to this alternative dispute resolution called arbitration. Well, what the problem with that is that it's very expensive. Arbitration is a neutral arbitrator or panel of arbitrators who makes the decision on your case. That decision is binding. It cannot be appealed. So if you don't like it, you're out of luck. And guess who pays those arbitrators? In the court system, the judges are paid by the tax dollars, are paid by the government. Right. But in arbitration, it's private, and so the parties pay the arbitrator's fees. So if an arbitrator spends 10, 20, 30, 40 hours presiding over your case, the parties are going to have to pay that arbitrator's hours. It's split in half, and each side pays half of the arbitrator's fee, but you can see how that adds up really quickly. So even if you get a favorable arbitration award, it's going to get cut down by the amount that you're going to have to pay to the arbitrator, and in some cases your attorney's fees as well. So arbitration clauses are really something to be aware of, but unfortunately you don't often have an option. When you go to the doctor, what are you going to do? Not go to the doctor?
Right.
Because they put that in there?
And then you're going to go see another doctor who has something very similar in nature to
have the same thing.
Yeah.
Right, they're gonna have the same thing.
They're not dumb.
Right. So those contracts are written one-sided.
Yeah.
When you go somewhere, they're written one-sided so that it benefits them the most. And you just need to be aware of what you're signing so that you can make an informed decision. Right. And not be surprised by it after the fact. You understand, I'm taking the risk that if this doctor commits malpractice, I'm going to have to go through the expensive process of arbitration. But this is one thing to be on the lookout for, because if you're in a context where you do have the ability to negotiate, you may want to cut out that arbitration provision because, like I said, of how expensive it can be.
Boy, for someone who didn't want to do this episode, she is getting fired up. Look at that, the passion.
I'm sure everybody is just riveted.
Oh, I'm sure.
By this conversation.
I'm sure. So,
do you love the Miss Biz podcast?
Because we love you.
Here's 3 things you can do to show your support.
1, write us a review. Apple or Spotify are the best platforms for reviews.
2, join us for our free Friday Zoom calls at 10 a.m. Eastern Standard Time. To RSVP, go to MissBiz.com homepage. Scroll down to Miss Biz Connects and click the link.
3, follow us on social media. Our handle is at Miss Biz Podcast.
As always, thank you for your support.
Basically, a breach of contract occurs when a party fails to uphold their obligations under a legally binding contract. This can involve anything from failing to deliver the goods or the services on time, or to not even paying the agreed upon fees. And they can be categorized as either material or immaterial. You want to go into what those mean?
Sure. Material is important. Immaterial is less important or unimportant. So a material violation is something that severely impacts the other side's ability to benefit from the contract. So a material breach would be, I did your website, you didn't pay me. Mm-hmm. That's important. Immaterial would be a minor violation. So minor violation might be, you did the website, but it was a week late. It wasn't on time.
Right.
It's not as important. So those are the different types of breach of contract.
Yep, and there's two main ways that a contract can be breached. So the first one is a anticipatory breach. That's where one party clearly indicates they won't fulfill their obligations before the deadline. And this could be through verbal communication or actions that demonstrate their inability to perform. And then there's actual breach. And an actual breach is when a party fails to perform their duties by the agreed upon deadline without any prior warning.
If you've ever done a construction project, then you know what an anticipatory breach is.
Yes.
They're supposed to meet certain deadlines and certain, accomplish certain things at a certain time, and
yet environmental forces always cause the delay.
There's always something that happens that is allegedly outside of their control, and that usually is in the contract too. It says we agree to meet these deadlines unless there's something that happens outside of our control, and there's so many things that can happen outside of your control. So it's we're probably all familiar with anticipatory breaches, but it's not only about deadlines. These type of breaches can be other things as well. It just applies based on whatever your circumstances may be.
So the consequences of a breach of contract are damages. So monetary compensation awarded, it could be awarded to cover losses suffered due to the breach. And this could be
compensatory.
Yes, thank you. I don't know what. So that aims to restore the non-breaching party to their pre-breach position.
Yeah. So both damages and compensatory are both monetary damages. So basically, if Rachel creates a website for me and I don't pay her, the compensatory damages to put me back in the position that I was is to reimburse me for the $1,000, plus I may be entitled to additional delay damages because I've now been out of a website for 6 months while you were creating it, or it may have taken away from other jobs that you could have been working on. So there may be interest and other types of penalties or damages. You have to go add up all of those things to figure out what the fair amount is. But that's compensatory damages, is putting you back in the position you were before the breach occurred. So that's what we do in lawsuits. We try to put people as best we can back in the position they were. I do a lot of homeowners insurance claims, for example. So a hurricane damages your house, insurance company tells you to pound sand and we're not going to pay for your damages. Then my job is to get the money that was needed to fix the home, put the home back in the condition it was before it got damaged in that hurricane. And there may be additional things that happened because of the delay of the insurance company that we also pursue. So there are other types of damages other than monetary damages. There can be the type of damages to get someone to take action. For example, they're holding on to your private materials and not giving them back. So you could file a lawsuit. There's not money to be exchanged there in that situation, but you're wanting them to be required to give back your materials. Or another common one is a trademark infringement or something like that. You're wanting them to stop using your trademark in their business. Those are other types of, we call them equitable remedies that are available.
And this, folks, this is why she's an attorney, because the level of passion right now that is flowing through her being is so strong. So we're going to have some fun now, and we're going to go through some real life examples of different breaches of contract. So our first example is Rida. He was awarded $82.6 million by a South Florida jury for breach of contract by Celsius Energy Drinks. The lawsuit, which was filed in May 2021, claimed that Celsius violated terms of an endorsement endorsement deal with Flo Rida's production company. So Flo Rida, he was the brand ambassador from 2014 until 2018. And during that time, he played an instrumental role in launching a new era for the company's brand development, along with their growth and expansion, and introduced the product to millions in the world. That's what the complaint said. But basically what ended up happening is he took them to court, and Flo Rida, he sought 1% ownership, which was initially promised in the deal, and he was willing to accept stock instead of monetary compensation. And the partnership between Flo Rida and Celsius significantly contributed to the company's growth, which is why he was awarded $82.6 million.
That's a great outcome, because looking at this case, it's tough to prove how much your product grew because of one person's brand partnership, unless there is a direct link where when you go buy Celsius, you put in the code Flo Rida,
right,
or something, then you can track it. But if it's just Celsius is sold at the grocery store, so it's hard to know how many people
saw the advertisement or got it from a concert or somewhere where he was promoting it. I know.
It's hard to prove that. It's hard to prove. So the fact that his attorneys overcame that challenge of being able to show how much Celsius grew because of Flo Rida's efforts is kudos to that attorney, because that would be a tough burden of proof.
You know what really showed me a lot about his character was that he sought the 1% ownership, but was willing to take stock in exchange for it. And despite the legal battle, he was still open to working with them and supporting them in the future. He just wanted his money. He just wanted what he felt he was owed.
Something else to be aware of, and this is important, is when lawsuits are filed, more often than not, we are going after insurance proceeds. The party who's being sued rarely is the party who's actually going to write a check if they lose. It's usually the insurance behind that party. And there are certain things you can get insurance for, and there are certain things you can't. And so in his mind, this type of a lawsuit probably wasn't something that Celsius had insurance to cover them for. So they're going to be paying out of pocket. So Flo Rida is trying to be like, okay, if I bankrupt the business and take all the money that they have, then that's not going to help me either. So what is a way that I can be compensated without bankrupting the business? So that may have been some of the discussion that was going on behind the scenes, but it's also important for you as a business owner to know that even though someone may do you wrong, if there's no insurance to cover it, and that party who did you wrong either went out of business or isn't financially stable, then you may have a hard time finding a lawyer willing to represent you, because they go get you a piece of paper saying that you're owed, but if they don't have the money to pay it, chances are you're not going to get paid.
Yeah, so forget what I said about his character, because that may or may not be true. I'm just kidding. I'm sure Flo Rida is amazing. But it's always good to be aware, because I think a lot of people don't realize or have access to that knowledge. Are you ready to take your business to the next level? Meet our expert team at Miss Biz.
Whether you need help with business strategy, brand development, or digital marketing, we have a personalized one-on-one coaching program just for you.
And if you're looking for something more budget-friendly, our group coaching services offer incredible value and the chance to learn alongside like-minded entrepreneurs.
Transform your business today. Visit missbiz.com and start your journey to success. Right.
So the next big breach of contract case, this happened here in Orlando, Florida, and it involved the band NSYNC. So basically what happened was the band was about to become millionaires, but when they opened their checks, one of the members, Lance Bass, said that the amount was for $10,000 each. And Backstreet Boys actually also claimed that they had only received $300,000 from all of their tours while they were working with Lou Pearlman, who had made $10 million, according to the 1998 lawsuit. So basically, after the attorneys found a loophole in their contract, NSYNC was able to leave Pearlman for Jive Records, and the band was hit with a $150 million breach of contract lawsuit in an effort to stop the move and to stop them from performing or recording using the name NSYNC, among other demands. So during this very public legal battle, the boy band manager was also running a Ponzi scheme, and that was under a brand that he called Transcontinental, I believe. And Pearlman convinced investors that he was building an empire. So in 2008, he actually pleaded guilty to conspiracy, money laundering, and making false statements in connection with the scheme.
So there's actually a Netflix documentary about this exact thing.
Really?
Yes, and I actually happened to watch it. I didn't know you had this example in here. So what the documentary says is that Lou Pearlman first created Backstreet Boys and then created NSYNC, but what they say is that Lou, he had this facade of being this multi-millionaire. He lived in a mansion and he wanted to create the boy band because he had been inspired by New Kids on the Block. He saw how well New Kids on the Block did, and so he thought, I got to get in on this boy band thing. And so he brought together the members of Backstreet Boys first, created them, got them the songwriting, got them the singing lessons and like all these things to help them be successful. But when they launched, they weren't successful in the United States right away. They were successful in Germany, but not so much in the United States. So he ended up signing an agreement with a publishing company to try to get them promoted in the United States. And in doing so, that publishing company got the lion's share of the wealth. So everyone's thinking that Lou was getting all this money. In reality, the publishing company who was making them famous was the one taking all the money. But this is an example of how signing a contract that's got unfavorable terms can destroy your entire business. The Backstreet Boys, after working for an entire year, according to the Netflix special, only made $10,000 for the whole year worth of work, each of them. And so, but they were young, they're 12, 13.
And this was a while ago, too.
Yes, but still, he said the comment that they made in the show was one of the Backstreet Boys said, well, how much did you make at Starbucks in a year? And they were like, oh shoot, I would have made more than this in a year working at Starbucks or wherever it was that he had been working. And so Pearlman had signed them into this really unfavorable contract. So the publishing company was getting all of the proceeds, and the band members themselves were left with next to nothing. And Pearlman himself was not making any money. The reason he was making all this money was because he was getting these investors who thought that they were investing in Transcontinental Airlines, which was not even a real airline. It didn't even exist. So he would have the boys sing for these investors, and the investors would be impressed and think these people are going somewhere, and then they would say it's all under this umbrella of Transcontinental Airlines. If you invest, you're going to get all this return. And then when they invested, Pearlman was just using that money to both live off of and to help promote the band. And then when he saw that, I think not producing enough income, he then created NSYNC and did the same thing with NSYNC. So it's a really interesting story. He ended up, yes, pleading guilty and getting a 25-year prison sentence, and then passed away in prison. And they said something like only 3 to 5 people went to his funeral because he had taken money from, they projected it to be over $100 million that he had taken from investors, and there was never any possibility that they would ever be paid back. He was just spending the money.
Right.
Because he was in over his head and had given away all of the profits to this publishing company.
That is so sad.
Yes.
I didn't know that about the publishing company because they always made it seem like he was the one that was directly profiting from it.
Well, that's what they thought in the lawsuit, I'm sure. I'm sure they thought he's taking all our money and he's giving us nothing. But when they actually dug in through what they call the discovery process and started looking, he had very little money in his account. And he was getting all this money from investors, spending it, and where all the Backstreet Boys money was going was really to this publishing company because of a contract he signed.
You know we're all about that case, no trouble. All about that case, no trouble. All about that case, no trouble. All about that case.
At Bolts Legal, we are all about your case. Text or call to schedule a free consultation for all your legal needs. boltslegal.com.
So this next example is pretty exciting. So in the mid-1990s, Pepsi launched its innovative Pepsi Points program. I don't know if you guys remember that.
Yes.
When you would get like the points on the bottom of the cap and you'd be able to like exchange them. Well, these points could be redeemed for a variety of different types of merchandise, ranging from apparel to exclusive items. And adding to the allure, customers were even given the option to directly purchase Pepsi Points for a mere 10 cents each. So the promotional campaign gained widespread attention with the unveiling of the captivating television advertisement, which borrowed its theme from the movie Top Gun. The ad featured a charismatic teenage actor who was wearing a Pepsi branded t-shirt, a leather jacket, the Avatar sunglasses, and they were showcasing the number of Pepsi points required to acquire each item that he sported. But the commercial then transitioned to a scene outside of a high school where 3 intrigued boys, one holding a Pepsi catalog, one of them was inside the school amidst a chaotic classroom scene. They're all looking outside the window, and then a jet descends out from the school grounds. The cool actor, he opens up the cockpit and he's like, sure beats the bus. And then the aircraft looms in the background, accompanied by a staggering price tag of like 7 million Pepsi points or something like that. And then the screen flashes with the slogan, drink Pepsi, get stuff. So fast forward, a 21-year-old student who, captivated by the ad, eagerly desired to obtain the jet, believing that Pepsi's offer was genuine, that he could exchange these 7 million points for the jet. So he was on a mission to get the desired amount of Pepsi points. After discovering that he could not purchase, or he didn't have the, I guess he couldn't purchase the jet for 7 million points, he enlisted the support of investors, including his friend Tom Hoffman, and he was armed with 15 Pepsi points and a check totaling the $7 million amount. So Leonardo, he submitted an order to Pepsi, eagerly anticipating his dream jet. But his excitement was short-lived when Pepsi promptly returned his check, accompanied by a letter informing him that the jet was not part of the Pepsi Stuff collection and therefore was not eligible for redemption under the program. So Leonard argued that Pepsi's commercial constituted a unilateral contract offer to sell the jet for 7 million Pepsi points. And according to the contract law principles, once an offer is accepted as per its terms, it's a binding contract that's formed. However, the Pepsi countered that the inclusion of the jet in the commercial was merely for entertainment purposes. So ultimately, the court sided with Pepsi, ruling that the commercial did not constitute a valid offer as it lacked the necessary specifics, and no reasonable person would believe that Pepsi intended to exchange a multi-million-dollar jet for a nominal fee. So despite Leonard's appeal, the decision was upheld by the Second Circuit Court. How do you feel about that, Brooke?
I think there was a valid contract because, as you said earlier when you were defining the unilateral contract, they put it out there. Maybe it was supposed to be in jest, but if they didn't have a disclosure saying this is just a joke, we're not really, and it is not a nominal fee. $7 million Pepsi points is a significant amount, and that's not a nominal fee, especially if you're 21 years old and you're looking at this. Imagine how many Pepsi products he had to buy. So he had consideration. He had to go out and buy and collect millions.
Yeah. And all of the
Pepsi
health
points.
problems too. Like he probably had like juvenile diabetes or something.
Well, hopefully he didn't drink it all.
Yeah, hopefully. He did enlist the help of a friend.
Gave it away or
Yeah.
did something else, dumped it out. I don't know, but I think that this was less of a. I think they were looking for an excuse to not enforce this contract because it was. There's no doubt the offer was made. It's in the commercial that everybody has seen. Mm-hmm. It was accepted by one person who then. His consideration was all the time and effort and money he had to put into collecting all of these points. And then how is it any different than all the other points?
Right.
That they agreed were enforceable. If you turn in your Pepsi points for a t-shirt, they give you a t-shirt because that's an enforceable contract.
Yeah.
But now you put it on a larger scale and all of a sudden it's not. What's the difference? Why is one enforceable and the other is not? So I think it was more because of, the ruling was more because of a practical approach. A judge is sitting there thinking, Pepsi doesn't have a Harrier jet. Where are they going to get a Harrier jet? They can't, that's not the type of jet that anybody can just go get. So it's not practical to enforce that they have to provide a Harrier jet. But could they have said, you owe him money for his losses for the time he put in? Yes. Like they could have compensated him in some other way, even though it wasn't practical to actually physically give him a jet.
I mean, they assigned a point value to it, just like they
Yes.
did with every other product that they displayed in the advertisement.
Right.
So I'm with you on that it was pretty implied.
And they should have written, Harrier jet 7XXXXXXX or something like that to put X's in place of the zeros. But instead they put a precise value amount in the same way that the ad had other lower value amounts coupled with other awards. So I don't see the difference. Maybe it was intended to be a joke. I can see why. But if they didn't disclose that it was a joke,
Right.
didn't put that disclaimer, then I think it's a contract.
Yeah. Well, the next one is.
Hold on, I've got one other thing to say.
Okay.
This, too, is another example of how your case, whether you can win or lose, varies based on what judge you happen to get.
Mm-hmm.
People call me all the time. I want to know, do I have a case? Am I going to win or am I going to lose? And we can never predict that because most cases, if they go to trial, are decided by a jury, which is 6 people who have a driver's license. And the 6 people you get today is going to be a different 6 people than you get tomorrow. And whichever 6 people you may end up with may rule differently and have different opinions than someone else. So it's always a risk in going to trial. And this is why it is, like, settlement oftentimes is a better option for many people because it avoids the risk and you get a sure thing. Had they had a settlement of this case, then the boy could have come away with something, I'm
Right.
sure. But it seems like they went the distance and got the decision of the judge, which was unfavorable.
Right. So the next instance is when Beckham sued Nike last year for more than $20 million. Beckham alleges in the lawsuit that Nike exercised a right of first refusal to match an offer he had received from Adidas, and that Nike later began withholding payments, citing technical violations of the agreement based on the shoes and gloves he wore during games. So Beckham explained when filing the lawsuit that he hopes to set a precedent that will protect other athletes against contractual gamemanship, right? Gamesmanship. So in this case, it's entirely possible that Nike had remorse for matching a deal at a time when Beckham's popularity was peaking, given that it dipped sharply after he was traded to Cleveland and tore his ACL during the 2020 season. And that it was looking for a way to reduce its financial obligations to a player whose best marketing days were behind him.
Yeah, this is a tough lesson that we can learn from too. A lot of times we enter into an agreement because things are good, money is flourishing, and we think this is going, let's say I sign on to a billboard deal for $10,000 a month, and at the time money is great, and then all of a sudden a building gets built right in front of that billboard to where now people aren't able to see it as much, or for other reasons business just isn't as good as it was, but I'm stuck in this contract for a year or however many years, and how do I get out of this thing? And this is kind of what happened to Nike.
You tear the building down.
Well, that's what happened to Nike. They were looking at, they couldn't predict the future. They didn't know that Beckham was going to get traded, and then he was going to tear his ACL, and then he wasn't going to be as popular. And they had given him this massive deal that didn't turn out to be profitable for them, so they started trying to get out of it. But because they had signed this contract, the contract is the legally enforceable document. So this is tough, and if you find yourself in a situation like this, the best thing to do, in my opinion, is to go back to that party and say, look, things have changed since when we entered into this agreement. I need to get out of this thing. I understand that you have put consideration into it too, so let's try to find a way that we can end the contract in a mutually beneficial way. You won't have to necessarily pay me, Nike, everything that you had promised, but I want to be paid for whatever time period I was playing or whatever it may be.
Right.
You negotiate something that is fair for both sides, is usually the best way to handle this. But if you've got a tough person on the other side who is wanting to hold you to the letter of the law, actually, this is bringing up another example. I have a former client who rented this massive space for her store, and then COVID hit, and nobody could shop. No one could go into her. And so she had this huge lease payment that she was responsible for. And she was in the lease agreement for like 5 years. And this was at the very beginning of her lease term. And she tried to talk to the landlord to be like, look, I'm not going to be able to pay these massive lease payments because we don't have any business coming in.
Right.
We didn't have any business coming in for a long time from COVID. And the landlord was just like, nope, contract says you owe it, and ended up suing her for the full 5-year tenancy. And she ended up having to file bankruptcy to get out of that debt because she didn't have anything in the contract that protected her from not being able to pay. If you don't pay, then you're out of luck. Now, her counter argument was, look, you could have found another tenant to take over, and they did next to nothing to try to find another tenant. And so they didn't really fulfill their obligation to find someone new to take that spot. But at the end of the day, that contract was enforceable. So it's tough sometimes when you get into contracts and then something unforeseeable happens that prevents you from being able to benefit from that contract.
Yeah. That's such a sad situation because who can predict that type of event
Right.
happening?
But it's also a lesson to try to do business with people who are trustworthy, that are understanding. This was like a big management company that was just like, if you don't pay, you're out of luck, we're suing you. Whereas if it had been a person-to-person interaction,
They probably would have been more likely to work.
work
with
something
her.
out to say, hey, we're going to try to get a new tenant in here. You're going to be responsible until we
Right.
do, and make a good effort to try to get a new tenant, and then that would have been fair. But to make her responsible for, but their position too, the building's position was, will we put in all these special features into this building for your particular store, like roll up garage doors and certain things like that. We did all this rebuild, or allowed you to do all this rebuild that isn't going to be what's needed for another business in the space, whatever. So there was arguments on both sides of things, but ultimately it was just a very sad situation where
having to file for bankruptcy because of it. I don't know. That just seems, I don't know how some of these people can sleep with themselves at night. Like, I understand, like, you can't lose out on money, right? You can't run a business and lose out on money. But like you said, they could have found somebody else to take over that lease.
But if you're a property management company and you're just doing your job, and you're the property management company for a huge hedge fund that owns dozens of commercial buildings all over, you're just following policies and procedures. There's no emotion going into it. And I think that's probably how they saw it, was there's a contract, it's black and white. I'm just doing my job. My job is to enforce the rights of my client who hired me to get them a tenant. I mean, it's just very...
They have no heart. That's what I'm going with. No heart.
It's very transactional, but also, too, they may not even have the authority, because think of what they'd have to do. They'd have to go up the ladder to somebody in a higher position of authority to make some accommodation for this unique situation, and that's more work on their part. And what motivation do they have to do that? They just file the lawsuit, and
I don't know, having heart.
well, they got, I mean, as far as I know, I don't think they got anything from it anyways, because she filed bankruptcy and got out of the debt. So they went through all that, the legal expenses and everything else, to get a piece of paper that never got paid.
Right. So what good did it do? See, that's why you gotta have a heart, guys.
Yeah, well, that's what I kept saying. Because I was trying to help her at points of it where I was saying, look, it's better to get something than nothing. If you file this lawsuit and you pursue this lawsuit, she's gonna file for bankruptcy and you're gonna get nothing. Mm-hmm. Whereas if you negotiate, you'll get something. So
Right.
I think in most cases, trying to negotiate for something is better than getting nothing. But they apparently disagreed with me.
Yeah, I can
So.
see that. Well, that was the example that we had for Nike and Beckham. Also hope that our other examples helped you and gave you some ideas of things that maybe you need to tighten up a little bit in your own contracts. We hope that you found value in this episode today. And if you have any questions, you can always reach out to us at missbizpod@gmail.com. Make sure you follow us on social media. And until next time, let's get biz done. We appreciate you and are honored to be on this journey with you. We can't wait to help you, to encourage you, and show you how to grow personally, professionally, and spiritually.
If you found Miss Biz helpful, please leave a review and share with others.
You can follow us on social media at Miss Biz Podcast.
For legal questions or services, please visit boltslegal.com.
And for digital marketing needs, please visit boltsmedia.com. Let's get biz done.